Welcome to the Caffeine Stream on Caffeine and Philosophy.
Alright, hello everyone, welcome to the Caffeine Stream. My name is CB Robertson, this is episode 22, and today we're going to try podcasting with no notes. But we're going to be talking about something that I've probably studied more than any other subject, so hopefully it'll go okay, and that is the First Amendment, specifically the freedom of speech part of it. Now, when you look at the First Amendment, people often think immediately of, the freedom of speech part, but there's actually a lot going on in the First Amendment. There's the, separation of church and state. There's the, petition government for redress of grievances part. There's the gathering part. There's a whole lot packed into that. And of course, one of the key phrases is Congress shall pass no law. So the right is in some sense a negative one and not a positive one. And in modern days, this is often imagined as this, right to say whatever you think without consequences. This is sort of the libertarian and conservative conception of the freedom of speech. And the problem that people will, at some point in their life come across is it's not really, first of all, it always seems hypocritical. It's always like whoever's not in power is pushing for, an absolutist free speech position, whether it's liberals in the 70s or conservatives now. But then once they get in power, they have their own ideas about what should be censored. So for conservatives, it's, blasphemy and pornography. And for leftists, it's, politically incorrect speech and like racist jokes and what have you. But there's some history going on with the First Amendment. And it's very often forgotten what it actually meant in its original case. Now, the book to read on this subject is called The Great Dissent. I don't remember the author's name at the time, but it basically goes over two court cases that happened in 1918 and 1919. This was during the First World War era, and it's alluded to by perhaps the greatest speech on this subject given in our time, which was Christopher Hitchens' defense of hate speech. I will leave a link in the description to that. If you want to hear the strongest possible case, defending something close to an absolutist free speech position, Hitchens is the guy to listen to. Anyways, the two cases we're talking about were, the first one, 1918, was Schenck versus the United States, and the second one in 1919, about 18 months later, was Abrams versus the United States. Very similar cases in many ways, but in the 18 months between these two cases, one of the Supreme Court justices had his mind changed, and and this was, of course, Justice Oliver Wendell Holmes Jr. of Shouting Fire in a Crowded Theater fame. Oliver Wendell Holmes had two friends. One, Harold Lasky, who was a socialist professor. A character Ayn Rand actually modeled one of her antagonists on in The Fountainhead. And he also earns a star place in George Orwell's essay on politics and the English language for bad writing. So it's a fun little bit of trivia. He's that kind of socialist. And but the second one is a liberal judge named Learned Hand. So this very strong conservative has these two very liberal friends who eventually persuade him that the freedom of speech means something different than he imagined it meant. They say, no, it has to do with this freedom of expression, it's this crucial to essentially to human dignity, to be able to express what's on your mind without consequence, essentially. And this ended up being what Justice Oliver Wendell Holmes wrote in his dissent in the Abrams case. And he gave some kind of post facto rationalization for why Abrams was substantially different from the Schenck case. But people often forgot what the freedom of speech was understood to mean prior to Abrams. Everyone has to bear in mind that the founding fathers who passed not just the Constitution in both forms and the Bill of Rights, within 15 or so years, within 10 years of passing this Bill of Rights and putting down in writing, Congress shall make no law, infringing on the freedom of speech, passed a law that made it illegal, among other things, to make fun of the uniform of the armed forces of the United States. And they saw no contradiction between these two things. So were the founding fathers tremendous hypocrites, or were they just not self-aware? Or did the freedom of speech mean something other than what we think it means now? The latter happens to be the case. We know that it was actually a technical term. The freedom of speech referred to a prohibition on what is called prior restraint. Prior restraint is a doctrine that emerged in England in the aftermath of the printing press, the Gutenberg printing press. In those days, in the late Middle Ages and early, Enlightenment era, it was the English government had been considering rules that said anything that was to be published with a printing press had to go through an approval process, essentially. Like, you couldn't publish it unless you had permission to do so. And in this, I don't know the historical details on whether it was passed and then rescinded, or if it was being considered or passed in some places but not others. But in whatever the historical context there was, who should emerge in this time but one of the greatest English writers of the last 400 years, John Milton. John Milton wrote this book, Areopagitica. And Areopagitica is not in the same school of thought as John Stuart Mill, as Christopher Hitchens, I think, somewhat egregiously grouped together. They were both defending freedom of speech of a kind, but John Milton was specifically defending against prior restraint. He was talking about the freedom of publication. And the idea here was that you could be punished for what you say. You could be prosecuted for what you say. You could not, however, be stopped from saying it. You couldn't have thresholds imposed upon you for, to even speak in the first place. So John Milton would say, yes, you should be allowed to shout fire in a crowded theater. Absolutely. However, if you are later found to have shouted it falsely, then you would be punished. That would be his thinking, anyways. You can't be restrained from doing it. So what we're seeing, for example, with social media censorship, especially algorithmic censorship, would in some cases be an example of prior restraint, interestingly enough. However, it's not coming from the government, so it's in a gray area. A really good example of this playing out in more modern times was, if you want to hear a good TED Talk, it's one of the best TED Talks, I think, out there. You can YouTube search Clay Shirky, Clayshirkey, and his talk on the various acts that the music industry has tried to push to try to license the ability to copy bits. I may be misremembering that exactly, but he opened his TED Talk very, very interestingly. It began with a picture of a cake printing shop. And there was a sign on the door that said, the cake. It was the sort of shop that you could bring in your own designs, like a kid draws a picture and you put the picture on the cake. It prints the image onto the cake. Kind of a cool thing. But the sign said that the cake printing thing was closed to the public. It's for professional use only. And apparently the problem that had led up to that sign is that one of the things kids like to draw is they like to draw things that they've seen. So they like to draw Mickey Mouse. They like to draw Disney characters. They like to draw all these other things. And it turns out when you print a cake with one of those designs, if your 6-year-old has hand drawn a picture of Mickey Mouse, that's a copyright violation on Disney, the company, and they will sue not the user, but they will go after the facilitator who permits that to happen. They'll go after the platform that permits that to happen. And so the effect of that is essentially prior restraint. It closed down the platforms to only people who have a license to do this in some kind of professional context, and it takes the users out of the creative role in their society. And so I'll leave a link to that as well. It's extremely worth watching and gets exactly to the heart of what this issue is, because Clay Shirky said this does not mean that commercial music pirates should not be prosecuted. They absolutely should be, but to prohibit that, to go into your machine and destroy its ability to do copying for illegal or legal activities is essentially equivalent to prior restraint, and in his words, flips the burden of proof from the assumption of innocence until proven guilt to the assumption of guilt. If you have this ability, you're going to be using it for bad purposes until proven innocent, i.e., you have a license and we can sort of monitor what you're doing. It's a lot more manageable for the corporate powers that be. And again, I'm not making an argument here one way or the other about what's good. We're illustrating the distinction between prior restraint and the sort of post-1919 concept of freedom of speech that we see coming out of Abrams. So that's a really important point to remember in conversations about freedom of speech and legality and so forth. It's not a very helpful point to conservatives these days who find themselves increasingly censored and harassed on campus for what they might have to say, and in outside of school in other places. But it really cuts both ways too, because this new 1919 concept of a much more libertarian free speech was primarily to the benefit of liberals who to that point could have been prosecuted, not just persecuted, but prosecuted in a legal context, perhaps, for spreading communist propaganda, which is now commonplace and totally permissible and legal, whereas it might not have been. So, to me, the strong case that everyone thinks is the strong case, I should say, against absolutist free speech is the case that Justice Oliver Wendell Holmes gave in 1918, the Schenck case, which is, the most stringent protections of freedom of speech would not permit someone to falsely shout fire in a crowded theater, thus causing a panic and stampeding people. It's a funny example because it turns out he was, first of all, it's a metaphor. And as Christopher Hitchens very artfully pointed out, the people, European socialists distributing these pamphlets saying we shouldn't be going to war in World War I. It's a hellhole. It's not our business. We shouldn't be getting involved. And we should, resist the draft to whatever degree we can. if we extend the metaphor offered by Justice Oliver Wendell Holmes, so like you can't shout fire in a crowded theater falsely. Well, in this case, the theater is actually on fire. It is a real war. So it's a bad metaphor to use, or it works the opposite way that perhaps the justice intended it to be meant. But it's almost hard to fault him for that bad metaphor, because he actually plagiarized it from another lawyer who had used that argument equally ineptly months prior, and sort of took this metaphor and applied it in in the Schenck case. It's a bad metaphor, and it was applied badly in that case, and I think it remains applied badly whenever people bring it up, because the whole question is, anybody who's bringing up an argument that, hey, there's a fire going on in the theater, the desire to censor that person, which is usually how free speech issues are phrased in a world of social media and supposed disinformation, ascertaining the truth of their claim requires some kind of investigation. Well, is there smoke? Can we see flames? Are the smoke alarms going off? Is there evidence of what what they're saying is true? And so often the would-be censors in this case are saying, well, we know the truth, so anything that contravenes this is obviously not true. An important ingredient in this fire in a crowded theater test, of course, was also urgency. The actual phrasing was clear and present danger. Is it clear, and is it present, like in the moment? If you don't do something now, someone will be hurt. If this person isn't shut up now, and he says, falsely shouting fire in a crowded theater is the example because it's a clear and present danger. Many of the things said online are, A, not clear, and B, they're not urgent. If someone says, guys, the 1969 moon landing didn't happen. It didn't happen. There's no urgent consequence from that. So it would be against Oliver Wendell Holmes standards to censor someone for saying the moon landing was fake, because there is no urgent consequence from that. It's also not clear. Yeah, there is some evidence, not proof by any stretch of the imagination. I am of the opinion that the moon landing did happen, but there is you can make a cogent argument that it was faked. I mean, the government has faked many other things, so it's like plausible that it could have been faked. So on that ground alone, it's it makes sense to sometimes hear those things out. Not that it would matter, in my opinion, if we did or did not land on the moon, but it's one of those things that is it's not in the immediate safety interest of the public to censor that. But returning to the actual subject of so if the crowded theater isn't the best example, because A, it's always a metaphor, it's always misused. What is the good example? I think the good example that pushes back against the sort of absolutist libertarian view of free speech is actually a little less interesting. It's just libel. It's just libel and slander. It is material harm to someone else in many cases. There's a lot of legal back and forth and argumentation of what is actual harm, how can you prove actual harm. Libel law is very complicated, and it's a very contentious subject. There's a lot going on there. Arguments for more serious libel law and arguments against more serious libel law. Nick Cohen has an excellent book, You Can't Read This Book, about how libel law was taken way too far in Britain. He describes cases where a Russian journalist exposing Russian oligarchs in a Russian magazine, webzine, in Russia, were taken to court for libel in Britain, in England, in British courts, because their libel laws were so lenient in favor of those charging libel. And the burden of proof is so high there that basically no one can survive a kind of libel charge if you say something negative. And the Russian oligarchs were successful because their webzine was readable on the internet in Britain, and therefore they had standing. So you get some ridiculosity in that direction, but you get some ridiculosity in the other direction too, where people can say just horrific and tremendously damaging things about other people with no consequences. And this is permitted on the basis of a supposed line between speech and action. That speech is a fundamentally different kind of thing than action. Like punching someone in the face is an attack, but saying something nasty about them is not. You should be able to conjure in your mind, 5 different examples of, things that someone could allege about you and the negative ramifications that could have on your life, where being physically assaulted might be preferable. For example, if someone were to persuade a large portion of your community or family, or even just begin a rumor that you might be a pedophile or a racist, a Nazi, for example, or that you, or maybe something more personal, maybe that you cheated on your spouse. It's a very hard kind of rumor to completely quash once it's started. Those are extremely serious and extremely damaging things. I would personally rather be punched in the face by, most people short of Mike Tyson than have someone, spread a rumor of that kind about me and have it take. So, and there's an excellent book, published by an English author whose name I forget offhand, but it's called How to Do Things with Words. And he gives the example of a priest at a wedding saying, "I now pronounce you husband and wife." He is actually doing something with his speech. He is performing an action with his speech. And that's a very formal, obvious example, but I think at the end of the day, there are all kinds of actions, or of actions that one can perform with speech. This used to be recognized by the fighting words doctrine. Indeed, as Vox Day has pointed out, and I have been intending to do a podcast on his works at some point. He's a very interesting thinker. It would be cool to be able to interview him. I don't think that's likely to happen, but we'll see. Has pointed out in one of his books, it's very, it's considered completely normal for people to, for people's actions to be censored, so to speak. You can't jaywalk, you can't physically assault people. There are all kinds of actions that we, prohibit, and actions are just as much an expression of our thoughts and feelings as our words and sentences. So, the idea that we would be, prohibiting people from expressing their authentic, true selves by not permitting them to say certain things that would apply to actions more generally as well. So he says there shouldn't be any reason why, libel should be legal. And of course, to drive the home point, Christopher Hitchens, the great, free speech proponent, famously sued Henry Kissinger for libel when Henry Kissinger accused Christopher Hitchens of lying, when Christopher Hitchens wrote very, very negative but true things about Kissinger and his associates. And of course, in the United States, truth is an absolute defense against the charge of libel. If what you say is true, it's not libel by definition. So, but it is worth addressing the question. So, okay, what the First Amendment is talking about with the freedom of speech isn't free speech as we understand it in a the contemporary American context, the ability to speak our minds without consequences. But shouldn't that also be a thing? Libel and maybe copyright and some other things aside, shouldn't we have more freedom on the scale of North Korea on one side to New Hampshire in 50 years on the other, libertarian-topia. Shouldn't we be moving more towards New Hampshire's and the Free State Project with free speech? In general, I do agree with that. In general, I think it's good to have more free speech. And I think the Founding Fathers, in writing this, would have agreed as well. I don't think the direction America should go is coming down on the side of Islamic totalitarians when they get upset with a cartoonist, for example. I think the state should be protecting that kind of speech. I think at the end of the day, what Americans want can't actually be defined that precisely in law. Someone I've been studying more closely in recent years is a French philosopher from the Revolution days, Joseph de Maistre. And de Maistre said that no country can write laws, really. You can't write a constitution down. The laws that govern a society either exist within the people and the people within their context, or they don't. And the Constitution, basically, the wordier a Constitution is, the worse it is. The more evidence that you're trying to fill in, fill in what is lacking in your society with words, and people just won't buy that. He pointed out that the French tried to write a new constitution, and the people looking back say, "Look, see, it worked. We got a new country." He said, "Well, the places where it worked were exactly the places where they ignored the Constitution, and at every point in which they followed what they had written down, it ended up not working." And I think when we look at some of the even beyond constitutions, even the way countries are named today, words and the names given to them, the idea of free speech promoted by the United Nations, for example, or the Human Rights Commission, which recently voted unanimously to not talk about the Uyghur situation in China. Another side fact. You can't replace what isn't there with written laws. And I think, to de Maistre's point, the freedom of speech is understood in a much broader sense than mere prior restraint in America, precisely because we Americans do have an unspoken law that is much broader than the mere the freedom of speech in the English sense, in the prior restraint sense. It isn't absolute. It isn't a full-blown free speech extremist position, but it is closer to that, and I think that is the position most Americans have. It's an unwritten law, and it's one that I like personally. It's more of a spirit than it is a law in the Constitutional Bill of Rights sense. And so you're not going to defend that second kind, that distinctly American freedom of speech, by appealing to the First Amendment, by appealing to the law on the books. But I think you will defend it by appealing to that common spirit, by saying, isn't this what we're all about? Didn't we come over here to have, in the American case, freedom of religion, especially if you're a puritanical Protestant, or an atheist, as I no doubt many of the early mountain men who also came over here, the fur traders and so forth, were. That's just speculation. I'm sure many of them were good Christians and Catholics, or whatever the Native Americans were as well. So, anyways, because I suppose I should conclude with this point, because freedom of speech does tie in deeply with freedom of religion, and there is a connection there, perhaps to be explored at a further point. But I think I've said most of what I wanted to say now on the subject, saying what freedom of speech, as elucidated in the First Amendment, is and what it is not. And for people who want to learn more about that subject, besides just listening to Christopher Hitchens, there's an excellent book to read, a very short book called Let the Students Speak. I'll include a link to the Amazon page below, because it covers the history of freedom of speech in America, in schools specifically. But in my experience, there is no better guide to understanding how the freedom of speech has evolved, how our understanding of it has evolved from 1919 to the present, than how it's evolved in the schools, because the schools are often forerunners to the rest of society. We've seen that play out many, many times. So I'll leave links to all of that below. Thanks so much for listening. Hope you learned a little bit and can take that with you out into the world. Thanks for listening.